Hello and welcome to a fresh episode of Legal Wrangle, where we will track major judicial developments that have taken place in the last few weeks in the world of international taxation. And the 4 cases we have selected are: the first one discusses the taxability of NRI on the basis of a frequent visit to India. The second one is about the payments made for transfer of non-exclusive license. The third one discusses the chargeability on the basis of business connection when no business operations are carried out in India. And the last case discusses the treatment of payments routed by Indian entity to overseas entity through parent counterpart. NRIs are often in doubt about the tax implications on their income due to complexity in the Indian tax regime. Our first case deals with one such situation, where the NRI's frequent visit to India landed her in trouble. Let's understand what exactly happened in this case.
The assessee in the present case is an NRI residing in Bahrain. During the course of her assessment, the AO observed that she had entered into frequent transactions of sale-purchase of shares. The AO thus made a presumption that she was engaged in the business of trading in securities. Accordingly, on the basis of assessment order passed for the assessment year 2008-2009, he made additions in the hands of the assessee under the head Income from Business and Profession. However, the addition was deleted in appeal order. Challenging the same, the department contended before the tribunal that the assessee, being an NRI and pursuing her teaching profession over there, keeps visiting India, and therefore an element of permanent establishment could not be ruled out.
Now let's see what the tribunal had finally decided. Frequent visit of an NRI taxpayer to India is no ground to presume that there existed permanent establishment and the engagement of business in India. Hence, her income is not taxable in India. Now let's move on to our second case, where the tribunal was approached to intervene and decide the taxability of annual membership cum license fee paid for a tenure of 5 years. The assessee is a non-resident company which had received license fees in terms of membership and technology transfer agreement. In this regard, ONGC was required to pay an annual membership cum license fee over the tenure of the agreement, which was for 5 years, for acquisition of certain specified licenses relating to reservoir sink technology. Such payment was presumed by the ITO to be covered within the definition of royalty and hence taxable in India. Though considering the fact and the assessee was resident of Canada, the AO applied the tax rate of royalty at 15% prescribed in the DTA. This action of the ITO was upheld by the first appellate authority.
Here is the final verdict of the tribunal. Payment received for transfer of non-exclusive or non-transferable license without any intention of sale of copyright cannot be treated as royalty, and amendments carried out under the domestic law cannot be read into the treaty provisions.
Let's move to our third case, where business connection of a taxpayer was adopted to determine the situs of the income. Now let's see what exactly happened in this case. The assessee acted as a canvasser in India for cruise packages, shores excursions promoted by SCMI in respect of vessels owned, chartered, managed and operated by Star Cruises Group of companies from time to time. The sale considerations were remitted without any deduction except for the one agreed upon between the parties. While passing the assessment order under section 195, the assessing officer dubbed the arrangement as being in the nature of a business connection between the two and estimated total profit, often non-resident, from the business connection of the turnover from India in terms of section 44B.
Now let's see what the High Court finally decided. In case of business of which all the operations are not carried out in India, the income of the business deemed under this clause to accrue or arise in India shall be only such part of income as is reasonably attributable to the operations carried out in India. And when no business operations are carried out in India, even if a non-resident has a business connection in India, no part of the income of such business can be deemed to have accrued or arisen in India.
Now let's move to our last case, where the tribunal was approached to decide as to whether payments routed by the Indian entity to overseas entity through parent counterpart will be construed as reimbursement exigible to tax. Let's understand what exactly happened in this case.
The assessee is engaged in the business of manufacturing, marketing and after-sale service of factory automation and process automation components, which can be broadly classified as handling of industrial electronic components and equipment and software development. During the course of assessment, the AO noticed that certain payments were made towards purchase of software to a non-resident entity without deduction of tax at source. It was contended that such payment was made to a foreign company towards reimbursement of cost incurred by it and not as a royalty. However, this was not accepted by the ITO and disallowance under section 40 subsection A clause 1A was made.
Now let's see what the tribunal finally decided. Simply because parent company had made payments to the licensor which was later on reimbursed by the Indian subsidiary to the parent company, it will not render such payment as reimbursement. Remittances made by the Indian subsidiary to the foreign licensor of software through their parent company will attract the provisions of section 195. With this, we wrap up this episode of Legal Wrangle. Keep watching TIOL Tube. Thank you and goodbye.